Good evening, everybody. Good evening. Hello, welcome, welcome. I do have comments off to start tonight so that I can read through my document here. Afterwards, I will be doing a Q&A to follow, but I am needing to start with the comments off just so I can get through the information with everybody. But welcome. Happy Thursday, D-Day, so to speak. Remembering all of our soldiers. Not very many of them are left to talk to us about what happened that day, but we are thankful for their service. So welcome in, everybody. So tonight I did do a post explaining that I was going to be reading through the sentencing memorandum for Mr. Bannon, just to kind of remind everybody about what the charges were against him. And what he was found guilty of. So we did have a hearing today in court where the judge said, I'm sorry, but you're going to need to go to prison, so we need to get that sorted out. And it has been 2 years since we had a verdict, so I thought it would be helpful to go through the sentencing memorandum just as a little bit of a information. What happens after you've been found guilty, much like what will happen with Mr. Trump, is that the state will submit a memorandum explaining what they think would be the best sentence, most appropriate sentence, and then the defense does. So in this particular case, I have the government's sentencing memorandum, and they go through and explain what the case was and what they think was the most appropriate sentencing. And then, of course, Mr. Bannon was able to submit his own thoughts as well. And then, of course, we have the judge that issued the full sentence, 4 months. Now, that, of course, was paused. He was allowed to be out on bail while he was appealing. But at this point, it's looking as though the Court of Appeals did not find there to be a appealable issue, and so the judge that presided over this case said, okay, you need to show up for jail. So that's really where we're at with this case. But again, I would like to remind everybody of how important this case was. This case was so important. And some people are saying, well, it's only 4 months and it was congressional subpoenas. But when we go through the facts of this case, I'll read you again through this memo. It's very important to kind of remember where we were on this and how long it's kind of taken us to get to this point with Mr. Bannon. So that's what I've got on our docket for tonight, everybody. So again, I do have comments off. I will turn them back on to do a Q&A after I have finished reading through the document, everyone. But did want to have a chance to get through the information first. So with that, I will go ahead and get started reading through this. Now, I do have a sticky note, especially just for you, Deborah, and anyone else. This is U.S. versus Bannon. This is the criminal number here. Thank you, John. So if you want to look up his case, any of the information about the jury trial, you can pull it up by pulling this number up. And then what I'm reading through is the government sentencing memorandum, and this was filed October 17th of 2022. All right, so let's go ahead and get started. And a lot of the information in this will probably take you back to some uncomfortable memories, everyone, but I think it's so important to remember what happened here. So here we go. United States' sentencing memorandum. From the moment that the defendant, Stephen K. Bannon, accepted service of a subpoena from the House Select Committee to investigate the January 6th attack on the United States Capitol, he has pursued a bad faith strategy of defiance and contempt. The committee sought documents and testimony from the defendant relevant to a matter of national importance, the circumstances that led to a violent attack on the Capitol and disruption of the peaceful transfer of power. In response, the defendant flouted the committee's authority and ignored the subpoena's demands. The defendant, a private citizen, claimed that executive privilege, which did not apply to him and would not have exempted his total noncompliance, even if it had, justified his actions. Then on the an about face representing to the committee that former President Donald J. Trump had waived executive privilege and freed the defendant to cooperate. But this proved a hollow gesture. When he realized that his 11th hour stunt would not prevent his trial, the defendant's cooperative spirit vanished. Despite the removal of the only purported barrier to his compliance, to this day, the defendant has not produced a single document to the committee or appeared for testimony. For his sustained bad faith contempt of Congress, the defendant should be sentenced to 6 months imprisonment, the top end of the sentencing guidelines range, and fined $200,000 based on his insistence on paying the maximum fine rather than cooperate with the probation officer's routine pre-sentencing financial investigation. There will be a lot of similarities here between Mr. Bannon and Mr. Trump, in my opinion, as we go through this. Procedural background. As the court is aware, and as elaborated below, on October 7th of 2021, the defendant defaulted on the committee's subpoena's demand for documents. 1 week later, on October 14th, he defaulted again, this time on the committee's subpoena's demand for deposition testimony. The United States House of Representatives voted on October 21st of 2021 to hold the defendant in contempt and referred his contempt to the United States Attorney for the District of Columbia to be proceeded against as provided by law. On November 12th, a federal grand jury in the District of Columbia returned an indictment charging the defendant with 2 counts of contempt of Congress in violation of 18 U.S. Code Section 192, 1 count for each of his willful defaults. And on July 22nd of 2022, a federal pettit jury found him guilty as charged. The defendant is scheduled to be sentenced on October 21st of 2022, 1 year to the day after he was held in contempt by the House. Relevant sentencing evidence. To determine an appropriate sentence, the court may consider all evidence relevant to the conduct of conviction, including evidence not presented to the jury, without regard to the rules of admissibility at trial. The court's finding of fact at sentencing are subject to clear error review. At the defendant's trial, the reason he willfully defaulted, that is, why he deliberately chose not to comply with the subpoena, was not relevant. Now at sentencing, it is. The court can and should consider the defendant's motive as part of his history and characteristics, and as a part of the nature and circumstances of the offense. The factual record in this case is replete with proof that, with respect to the committee's subpoena, the defendant consistently acted in bad faith and with the purpose of frustrating the committee's work. The defendant's default. On September 23rd of 2021, the committee issued the defendant a subpoena for documents and testimony. The committee did so because it had reason to believe that the defendant had information relevant to its investigation. For instance, the defendant had reportedly gathered at the Willard Hotel on January 5th of 2021 to persuade members of Congress to block the certification of the Electoral College vote. And on the same day, the day before the attack on the United States Capitol, the defendant predicted on his podcast that, quote, all hell is going to break loose tomorrow, end quote. The subpoena required the defendant to produce responsive records by October 7th of 2021, appear for a deposition on October 14th, and set forth rules for how the defendant should raise privileges and objections, specifically through a log of withheld records in lieu of documents, and in person on a question-by-question basis during testimony. The defendant's attorney, Robert J. Costello, accepted service of the subpoena. The subpoena's first deadline for documents was October 7th of 2021, but after receiving the subpoena, the defendant did not begin searching for responsive records. Instead, he began searching for an excuse not to comply. Mr. Costello, the defendant's lawyer, with whom the defendant worked closely throughout the process of responding to the committee, and by whom the defendant was provided and apprised of all correspondence with the committee, began calling around to identify a lawyer for former President Trump to make an assertion of executive privilege. He did so even though executive privilege could not possibly permit the defendant's total noncompliance. The defendant was a private citizen who had not worked at the White House for years. The subpoena's demands sought records and information wholly unrelated to the defendant's tenure there, and multiple categories of the subpoena were completely unrelated to communications with the former president. Ultimately, Mr. Costello received contact information for the former president's then attorneys and initiated contact with one of them, Justin Clark. On October 6th of 2021, Mr. Clark sent Mr. Costello a letter that stated that the subpoena sought records potentially protected from disclosure by the executive and other privileges, and directed the defendant to the fullest extent permitted by the law, and where appropriate, not to produce documents or give testimony concerning privileged materials. The Clark letter did not direct the defendant to withhold any specific document under any privilege, and unlike similar letters that Mr. Clark sent to other individuals who had received subpoenas from the committee, it did not inform the defendant that the former president believed he may have immunity from appearing because of a role as a high-level White House advisor. That is because Mr. Clark was unsure whether the defendant had any privileged documents or information at all, because the former president did not believe the defendant had immunity from testimony. And we have a direct quote here. Let me start with the quote on this page. Clark does not possess, nor has ever possessed, any knowledge of Bannon being in possession of documents, information, and or testimony which would be protected under executive privilege. Former United States President Donald J. Trump also did not believe Bannon possessed immunity from complying with the congressional subpoena. As such, that is why the instruction letter provided to Bannon was written differently when compared to other instruction letters. Both through its own qualified language and given the committee's clear rules for raising objections and privileges, the Clark letter did not exempt the defendant from complying with the subpoena. But that did not stop the defendant from exploiting the Clark letter as an excuse to ignore the committee's subpoena. On October 7th of 2021 at 10 a.m., the defendant allowed the document deadline to pass without any attempt at compliance. He failed to produce a single document, and he did not contact the committee to request an extension or otherwise negotiate regarding the subpoena's demands. Indeed, by that time, the defendant had taken no steps to identify and collect responsive records. And then we're quoting here, Costello was not prepared to respond on Bannon's behalf on October 7th of 2021. At that time, Costello did not know what Bannon possessed that would have been responsive to the Select Committee subpoena. Later that day, Mr. Costello sent a letter to the committee stating that the defendant could not comply because of Clark's letter. Mr. Costello sent this letter even though, when later speaking with the government, he conceded that not all topics listed in the schedule could possibly implicate executive privilege. The next day, on October 8th of 2021, the committee promptly rejected the defendant's claims. The committee pointed out that the Clark letter did not constitute an actual assertion of executive privilege, and even if it had, most, if not at all, of the subpoenaed items could not possibly implicate executive privilege. The subpoena required the defendant to provide non-privileged documents and indicate in a log any records withheld under the privilege claim, and the subpoena required the defendant to appear for deposition on October 13th and assert in person any objections on a question-by-question basis. Further, the committee warned the defendant that his noncompliance could result in a referral for criminal prosecution. At the same time, the defendant was publicizing and celebrating his defiance of the subpoena. He gave an interview to the Daily Mail, providing a reporter with a copy of Costello's letter to the committee and stating of his noncompliance, quote, "I stand with Trump and the Constitution." The defendant then posted the related article on a social media platform. The defendant and Mr. Costello did not respond to the committee's rejection and resolution of his claims for several days. In fact, their next contact was initiated on October 12th of 2021 by a committee staffer who reached out by phone to Mr. Costello to arrange logistics for the defendant's deposition, which was scheduled for 2 days later on October 14th. Mr. Costello indicated in that phone conversation the defendant was unlikely to appear. On October 13th, the committee staffer followed up by email and had 2 additional conversations with Mr. Costello. Mr. Costello was clear the defendant would not appear for a deposition as commanded by the subpoena. Unbeknownst to the committee, while Mr. Costello was continuing to claim on the defendant's behalf to the committee that executive privilege required the defendant's total noncompliance, Mr. Clark was cautioning the defendant that it did not. On October 11th of 2021, Mr. Costello sent a text message to Mr. Clark demonstrating that he understood that the former president had not yet invoked any privilege as to the defendant. Costello writing, quote, "What is President Trump going to do about asserting executive privilege with respect to Steve Bannon?" And on October 13th, seemingly because the committee staffers repeated inquiries, Mr. Costello forwarded to Mr. Clark the committee's October 8th letter rejecting the defendant's claims. According to Mr. Clark, he had a phone conversation with Mr. Costello around the time of his receipt of an email in which he reiterated that there had been no assertion over any specific document